G'day, I'm Michael Tessaro. I prepared this ACCC cheat sheet for December 2025. And the way I do it is I summarise all the ACCC developments which occurred that month, which in the case of December 2025 is a lot of stuff, a lot happened in that particular month. So I guess also you can see that I'm doing it about mid-January, so I'm not too far behind. So hopefully I'll be able to keep up to date and get these out as I should shortly after the month ends. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to say legal consulting for the last 18 or so years. I help individuals and companies with competition and consumer law matters. Also do some expert consultancy work for various legal publishers on competition and consumer law. And I have a part-time role as general member of New South Wales Civil Administrative Tribunal, where I do a variety of things, but a big chunk of it is adjudicating on Australian consumer law complaints, often about cars. And prior to that, I worked at the ACCC for 15 years in a variety of roles, relevantly in enforcement. And the outline's quite long. There's a lot of court action, a lot of enforcement action, some very interesting merger matters, um, some depressing inquiry and consultation reports, and some other interesting things at the end there. Now, one of the big three cases in December was the Google case, and this was the one that involved an agreement between Google, Telstra, and Optus, and actually TPG as well, effectively to allow Google to be the exclusive search engine on Android phones sold by Telstra and Optus. This relates to Telstra and Optus. TPG also had an agreement with Google, but for some reason not including this. And what's happened is Google entered into agreements back in 2019 with these three companies and said, okay, you make us the exclusive search program on your Android phones that you sell to people, and we'll share the monopoly profits we get from that with you in terms of advertising revenue. We share that with you. It just dead set clear illegal behaviour. They were proposing to enter into new agreements and they were proposing to get rid of this illegal exclusivity agreement. However, they didn't undo the fact that the previous conduct was illegal, and Google's agreed to pay $55 million penalty. Also, Telstra and Optus have signed an undertaking, as you can see, not to do this again, so it's TPG, not to enter into illegal agreements with Google or anybody else to provide a default search function on an exclusive basis. So this is very bad conduct and historical, and they seem to have realised it was illegal and stopped doing it. But I'll talk more about it at the end. But I think 55 was a bit on the low side. I would have doubled that easily. Now, ACCC and Boop is another very serious case. Again, by agreement, Boop agreed to pay $35 million for misleading its members and also unconscionable conduct. Most of that is for unconscionable conduct, and the conduct was very unconscionable. Effectively, and I think they introduced some systems that really didn't properly assess claims. Also, they removed some fail-safe mechanisms, which should have had claims double-checked by I don't know, by a person or by a program or something. And as a result, they engaged in some very extensive misleading and unconscionable conduct. So from 2018 to 2023, so 5 years, they effectively were telling people, members, that they weren't entitled to particular hospital benefits when in fact they were entitled to those benefits. So people are coming along and saying, I need treatment for this condition, and they're going, sorry, not covered, too bad. And the person is either upgrading to get coverage or doing it out. Both things shouldn't have happened. They were covered for the thing. So ACCC, or the treatment. ACCC got an admission out of Bupa. They engaged in unconscionable conduct in relation to this conduct, the incorrect assessment of some mixed coverage claims. So what that was about was somebody would ring up and say, hey, I need two things, and one of them was covered and one wasn't, so I need two treatments. One's covered, one's not covered. And for some reason, the systems that Bupa had in place would reject the whole claim, so that you're not eligible for anything. So again, these people would go off and say, hey, I've either got to upgrade, pay more money, or I'm not going to get the second procedure done. So the ACCC provided a court enforceable undertaking to remediate all these poor members who were misled and didn't get what they were entitled to. And as of the date of the court case, $14.3 million have been paid out in relation to 4,100 effective claims. So very, very poor conduct by Bupa. This is ACCC in Fewstone, which is not really very well known, but it's actually City Beach. And there's actually two decisions, I guess. 12th December, the federal court found that Fewstone had, engaged in a breach of legislation in relation to the mandatory standards on button batteries. And then there was a penalty hearing, and the judge quickly got a penalty decision out, which is the reference there. So you've got 12th of December, you've got a decision on liability, and I didn't see a judgment on that. Maybe there was a judgment, I don't know. And then you see a bit later the penalty judgment coming down. So the court found that between 2022 and 2024, City Beach sold more than 60 product types containing button batteries that did not comply with the button battery safety standard. So basically, the three things you need to do: you need to have a warning, you need to test them, and you've got to make sure that kids can't get access to the button batteries. And I understand these products pretty well failed on all three, so that's very serious stuff. It was cheap novelty products, clearly directed at kids, so toys, digital notepads, keyrings, etc. And they sold a lot of these products, so 54,000 breaches. Now, I'm just wondering whether they're tripling up. They're sort of saying where you breached, every time you sold one, you breached the standard in 3 ways. Not too sure. But it's a lot of breaches. It's 54,000 breaches. And these are some of the products. You can see they're very cheap little products, but very, very directed at little children. That's not the kind of thing 16-year-old kids are going to play with. They're very young kids. And then the penalty came along. So here there was a bit of a fight about the penalty. ACCC wanted 14. City Beach was saying it should be less. I think it's talking about 4 million. And the court went through everything and decided that 14 was appropriate. The court observed that the pervasive failures by City Beach to inform itself of its obligations, which could cause serious harm, was very concerning. Put the lives of more than 50,000 young children at risk of severe injury and death, and said the lack of urgency in seeking to recall the non-compliant products was condemnable, which is a funny word when you think about it. But anyway, these judges like using funny words sometimes. I guess the key thing here is when you read the judgment, you see that a few state fair trading departments are writing to City Beach and warning them, saying, hey, your products aren't compliant, and that information is sort of ending at the store level, not going to senior managers. Senior managers seem to be totally oblivious to this particular standard, which, I don't know, they've been living under a rock or something. And the processes were really very, very not very efficient by the sounds of it. So they started withdrawing products from sale, but then a couple of further products slipped through. Didn't send a very good message to the court or to the ACCC that this particular company had good compliance culture. This is a little case that just I stumbled across. A man called Stephen Michael Wicks sued the ACCC because he was unhappy that his complaint about InvoCare, and I don't quite understand what the complaint was about, wasn't actioned by the ACCC. He thought that they should have pursued it. And so he commenced proceedings in the Federal Circuit Court, I think it was, or no, Federal Court actually, under the ADJR Act, saying that the ACCC has breached that and should be forced to make a decision. And the pretty simple case, the court said, well, there's not a decision under enactment. ACCC is not required under the legislation to make decisions on people's complaints, so the ADJR Act doesn't apply. In terms of enforcement, the first one involved the Commonwealth Bank, and this was a fine of $792,000 for breaches of the CDR's Consumer Data Right Rules. And again, the bank's been in trouble here, and AB got trouble a while ago, and effectively they did not comply with the rules by failing to enable data sharing for certain accounts for business, consumers, and partnerships. So it's supposed to be able to facilitate the movement of these consumers' information to another financial service provider, and they weren't doing that properly. The CBA seems to have cooperated with ACCC, said we're going to fix up the way we're operating, we're going to enable consumer data sharing for remaining trading entity business name accounts, and they committed to a time frame, pretty short time frame, 10 days, and also provide remediation. But this is showing, even the big guys are getting it wrong with the CDR. ACCC commenced legal proceedings against a company called Grocery Delivery E-Services on 16th December, and this company operates both Hello Fresh and U Foods, and alleging misleading subscriptions. So this is a priority area for the ACCC, subscription traps, is sort of described by the ACCC. And it's only an allegation here, but the ACCC has alleged that basically these two companies were advertising on the websites and their apps that you could just easily cancel subscriptions through the online account. You had a specific time to cancel, you would be charged anything, and the ACCC's alleged that wasn't happening, that people tried to cancel subscription online, they still were charged for and received the first order. So most likely it's a bit of incompetence by the companies if it's proven to be true. But it's a big level of incompetence. They're obviously big providers. So you can see between that period, 62,000 HelloFresh customers and almost 40,000 New Foods customers were charged a fee despite allegedly cancelling their subscription before the specified cut-off date. So if the allegations are established, it's a big fail by these two companies. Equifax. So Equifax, as people know, is a very big provider of various financial checking information, and it entered into an agreement with one of its customers, basically Choice Services, which is one of the largest holders of payroll and superannuation data. But it was an exclusive agreement, so they were going to get all this information, from this company exclusively, which I think they should see from the view has got probably less competition in the market. Equifax is very big, and it's denying access to this data by a lot of other competitors. So ACCC has decided to resolve this with a ACCC undertaking not to take them to court. Probably a lucky break for Equifax because this is a priority area. I think 47 is still a priority area, and it sounds like it would have less competition. But I guess ACCC wanted to resolve quickly, and sometimes an ACCC will get you a result much quicker than some litigation. RPM, bit of an outbreak of RPM in December. First one was Golf Imports, and they're an importer of golf products. And they basically were telling their customers, you can't sell below a set price. So as you can see, the contract was for about 3 years, and the clauses in their documents on their website saying you can't sell, if you're a retailer, below the golf import specified price. And as you can see, there was agreements which include a term. They suggested they actually imposed it, like I said, you're selling below price, so we're going to punish you. But clearly, by having such a clause, it's against the law. And I guess ACCC has decided to resolve with the ACCC undertaking. Probably, I don't know how big golf imports are, but obviously not sophisticated, didn't know this is a breach, probably. Another one, which I'm assuming same scenario, don't know how big it is, but wasn't aware of the law probably, and it's industrial drone supplier EE Group, and it was effectively admitted to engaging in RPM, directing certain retailers not to sell their drone products to consumers below a specified price. As you can see, it didn't go very long, April 24 to June 25, and effectively it was saying don't sell it. And I think it did also sort of, I said, inform some resellers, probably threatened them that it would not supply them with a DJI drone if they did not agree to sell above a particular price. So probably a bit more serious than the golf one. A couple of mergers. Igneo Infrastructure Partners wanted to buy Benedict Recycling. The ACCC expressed some concerns. It makes sense. These are high barrier to entry markets in many respects, particularly environmental planning laws. And so what happened here was ACCC said it's a breach, identified the areas where they had concerns, and the parties restructured the transaction to take out the area of concern. So effectively that was the Newcastle Recycling Centre in Mayfield West. So now that's no longer part of the sale. The whole business unit's being carved off, assets, staff and equipment, and effectively the rest is going to be sold to Igneo, and the ACCC is happy with that. And then the Benedict's going to keep operating the market as Newcastle Recycling Centre. So that means they'll remain in the market as a competitive force. How competitive they're going to be if they lose scale, I don't know, but at least they should have an incentive to keep competing. This is a big one, IAG and RAC, and this is on the insurance part of RAC, not the whole business. And ACCC initially identified some competition concerns and has now doubled down on those concerns and said it's a breach. And they're concerned that the merger would result in lessening competition, the supply of motor vehicle insurance, and the supply of home and contents insurance WA. And they talk about the combined firm. It's bringing together two large insurers, and that have a market share of approximately 55 to 65% in motor vehicle insurance and 50 to 60% in home and contents insurance. Now, I'll just say here that I just don't think this is a breach. I don't think these are state markets. Let's face it. You can sell motor vehicle insurance from anywhere in Australia to anywhere else in Australia, and the same home and contents insurance. I just can't see these are local markets. And also, I think it's a little bit misleading saying that two large insurers there's no doubt RAC insurance is very big in WA, probably maybe through parochial considerations, I don't know, but IAG is not big in WA. So to say it's a large insurer is a bit misleading because IAG is a large national insurer, but it's not a large insurer in that market. So I think ACCC's got this wrong. I think if it goes to court, they're going to lose, I think. ACCC carefully considered the level of competition provided by these other providers. It must have concluded it wasn't going to be adequate. Suncorp, Allianz, QBE. It's hard to believe that they're not going to provide good level of competition. Auto in general, UE, Hollard, they're pretty significant players in the market. ACCC found that although alternative insurers compete in WA, they'd be unlikely to prevent the significant loss of competition. And finally, they considered RACI's, financial position. Is it in a position where it's maybe going to go broke? There are some material insurers that are struggling to get coverage, and that's been the case with some of the other state RACs. They've looked at it. Maybe the ACCC doesn't think there's a financial issue there, that if the merger doesn't go through, it's going to continue competing in the market. Maybe somebody else could buy them who has maybe no interest in that particular local market or state market. Another one, Yamaha Motors and Telwater, and this is a one where the ACCC again announced had some serious concerns. Yamaha supplies Appwood Motors, and Telwater provides aluminium trailer boats. And ACCC thinks they're going to lessen competition in the wholesale supply of Appwood Motors. And effectively, they're concerned that they're concerned that the Yamaha Telwater Group will have an ability and incentive to leverage Telwater's significant market position in aluminium trailer boats into the Appwood Motors market. So basically, say, hey, if you're a retailer of our products and you want to sell Telwater aluminium trailer boats, you also have to sell Yamaha Appwood Motors. So basically, bundling the two products together to exclude competitors, probably charge high prices. So that's a concern. Horizontally, there's no overlap. They're not in the same market. It's really a vertical concern. ACCC believes that some bundling or tying, or however you want to put it, could occur, could lessen competition. Again, I'm not too sure these markets either of them are really high barrier markets. I can't see aluminium trailer boats being a high barrier market, and that's on the assumption that consumers wouldn't be able to say, well, Telwater, Yamaha, get stuff. We're not buying your aluminium trailer boats. We're going to buy them somewhere else. It just seems to me that's an obvious thing that could happen. So I'm a bit surprised at this one. Coles Supermarket, the big retailers are required to tell the ACCC when they make acquisitions. This has been determined by the Treasurer. And they're also required to tell them when they purchase leasehold interests. So here's what has happened. ACCC has announced that it will not oppose the acquisition of two leasehold interests in Victoria, Mount Atkinson and Deanside, on the condition that Coles sell off the Cororoit site to somebody else. So the concern that local markets, so that's been well established in the case law that the local markets, and so having these three interests in the same market and existing supermarkets obviously in the same area is going to likely to lessen competition in that localish market, and so they've got to sell something off. So they conclude that Mount Atkinson, Deanside, Cororoit are all very close together in the Melton growth corridor, and that they would have too much market power, and so they've got to sell off one. They've chosen Cororoit to sell off. I don't know to who to, but they've decided to get rid of one. Then the ACCC issued a warning, and this comes out of the Black Friday sweep that they did earlier in the year, where they discovered a lot of problematic behaviour. As you can see, countdown timers, and also saying, it's going to be extensive discounts when there really aren't. And so the ACCC wanted to warn all the retailers before the Boxing Day sales, don't do this sort of stuff again. Avoid it. And I think it's very misleading. The countdown timers, you just think it's going to run out. I better buy it quick, and I think I've been guilty of that. And then the countdown timer runs down and resets, and also the scope of discounts. So a lot of bad deals on Black Friday, and I think they're worried about the same thing happening in Boxing Day. And I think that people are being warned twice, retailers are being warned twice. There'll be a bit of enforcement action, probably in the next couple of months, arising from Boxing Day. So Scam, the National Anti-Scam Centre, issued a media release urging Australians to check twice when shopping, gifting, or travelling. So I guess they're saying, you just got to be very careful. A lot of scams arise around Christmas time. But there was specific reference to what they call hard copy scams. I hadn't heard that particular terminology, but what it is, it's talking about these, things come in the mail. So that's what hard copy is, not online. And financial losses, you get something through the mail. It says scratch here, and you've won some money. You've got to send us some cash, and we'll give you the money you've won, or something along those lines. And so it's really old-fashioned type of scams. I reckon there's a lot going on at the moment, promoting fake travel giveaways, instant prizes, low-cost wins, and all the rest of it, discounted holidays. So that's made a resurgence, and they're warning people about it. I remember when I was at the ACCC, it was all a bit pre-online scamming, and then we used to say the White Shoe Brigade on the Gold Coast. So used to run these confidence scams. And it sounds like that sort of thing is happening again. I don't know quite why. Uh, maybe maybe something comes in the mail, you're less likely to think it's dodgy than something that comes over the internet. We've been programmed to be very suspicious of online promotions, but maybe something comes through the mail, you trust it more, particularly maybe older Australians, I don't know. And here's an example of one, the 7th anniversary promotional event. So you scratch that, probably tell you you've won $185,000, and you've just got to do some stuff to get your money, and that's where you get ripped off. Airlines, not very good reading. 9th December, ACCC issued the Domestic Airline Competition Report. Very high demand for domestic travel, not enough seats, prices going up. Carried 4% more consumers in October 25 than in October 24. They added a bit more capacity, 45 additional flights, but they're not offering enough additional capacity. Why would you do that? You're making so much money off the limited capacity. Air has decided to buy Rex, so hopefully that provides, I guess, as I said, their reassurance to communities that regional connectivity will continue. I don't know if there's going to be a lot of competition to Qantas and Virgin, but at least the regions will continue to have airline services if Air can stay in the market. And then finally, and not surprisingly, the financial results for Qantas and Virgin show they're making heaps of money. And that makes sense because they don't compete. Petrol, I guess here prices have gone up in both petrol and diesel, and that makes sense, I guess. There's a lot of international developments which which result in higher prices, and so we know that there's nothing there's no domestic funny business going on because the increases in petrol and diesel prices in Australia can be tracked to international developments. One observation they made here is that sales of regular unleaded petrol have been declining over time. They've identified fuel efficiency and travel patterns, working from home. I think probably maybe electric cars has a big part to play there. I'm surprised they referred to these other two things. But I guess as the amount of petrol being refined and imported to Australia reduces, obviously costs are going to go up because a lot of fixed costs that get spread over the amount you're purchasing. I guess a good example is I bought my daughter a record the other day, and it was like $80. I couldn't believe it. And I'm thinking, why is it so expensive? And I guess it makes sense. When I was growing up, I used to probably make millions of records, and so the price per unit was reduced. But nowadays, I imagine they make very small runs, and that results in the high prices. I guess that makes sense economically. I don't know if it's quite right. And the ACCC also observed that every state and territory now has a fuel transparency scheme in place. And there's the diagram that they include in their reports, which summarises all the findings of their reports. Some very, very depressing reading of stevedores. Here, the ACCC released its container stevedoring monitoring report and found that Australian stevedores are charging ridiculously high prices, and they basically haven't made as much money uh, as they are at the moment since any time in the last 27 years when the ACCC started monitoring container stevedoring prices. So they're going hard, they're ripping off their consumers, and I think the problem here is sometimes you push a bit too hard on issues like this. You know, it's a valuable public resource. Uh, the government's going to step in and regulate, and that's what the ACCC said. They're saying the government's got to get in here now and introduce some changes to regulate the amount of money the stevedores are making. So that's great to hear the ACCC calling for that. And when you look at the financials, it's just outrageous, really, how they've been doing. As you can see, the earnings before interest, tax, depreciation, and amortisation. As you can see, the operating profit has increased from 457.8 million to 808. So it's a 130% increase in operating profit. And there's really no reason for it. Like there's no um, major cost increases or anything like that. So they're just, gouging. Operating profit has now increased 14.5% over the past 5 years. Now they're making 34.8% a year in operating profit margin. That's ridiculous. That's so high. It's not like rocket science. Like they take a box off a truck or a train, they put on a boat, or they take a box off a boat and put on a truck or train. Like it's not a big value add really when you think about it. Return on average tangible assets increased 30 percentage points to historical 45%. So they're recovering their tangible asset revenue in 2 years, 45%. It's outrageous. And as you can see here, in 2024-2025, the stevedore industry collected over half, 50%, or 1.15 billion of its revenue from landside charges, which is almost equal to the entire investment stevedores have made collectively over the last 8 years. So they're investing and they're getting back their investment in 2 years. It's ridiculous. So they make 8 years of investment and they recover that in 2 years. And then more than 642 million of the 1.15 billion landside charges came from terminal access charges alone. So they're very problematic. They've overdone it. They're going to get regulated, sucked in. Probably should say that, but it just drives me nuts because I did a lot of work on the waterfront with the Maritime Union. I investigated all the stevedores and the whole market's got so many failures. Everybody's gouging along the way, and the frustrating thing is the government periodically bails out the stevedores by paying all their redundancies when they get rid of all the Maritime Union guys. So the Maritime Union guys get big redundancies paid for by the government, and then the quid pro quo means they're supposed to provide services at an efficient price, but they don't do it. They just screw the customers. So I think it's very good that they're proposing regulation. NBN, this was interesting. The NBN decided to upgrade its programs, and as a consequence, and this was high-speed NBN plans with fibre to the premises of hybrid fibre coaxial. So I decided to upgrade the plans, and this is no extra charge for retailers. So basically, people who were getting 120 megabytes per second are now getting 550. So that's gone up a huge amount. If you're getting 250 and 25, now you're getting 750 and 50. So that's a big increase. And if you're on 1,000, unfortunately, your upload speed's gone up to 100 now, but your download speed's still 1,000. But that's good. I guess the thing to realise here, that's a good outcome, but realistically we're a long way behind a lot of the rest of the world in terms of our speeds. So it's probably catching up. We're really catching up. Gas, again, this is quite interesting because the the ACCC released a report and said it looks like we're going to have enough gas supply in the second quarter of 2026 domestically. The southern states are going to have to import it down from Queensland, and so it looks like we're going to be okay. However, and this is the big thing, however, we could have 15 petajoules surplus, or we could have 8 petajoules shortfall. So that's a very big range. And how are you going to plan as a business if you use gas if there's potentially going to be a shortfall? it's not a way to run a business. So it all depends on whether companies want to sell their uncontracted gas overseas. And it's probably one of the three. I think Santos is the guy who's doing most of the damage here. The other two are trying to do the right thing. And so the government didn't muck around. Like 17th December, the report comes down, and a few days later, the ACCC said, stuff this, we've decided to introduce a gas reservation scheme. Now, they're going to talk to people about it, but the proposal is that 15 to 25% of the gas extracted is going to have to remain in Australia for local use, which has got everybody up in arms a bit. But realistically, you can't be playing these games with your consumers, your customers, and the government for so long and not expect to be a regulatory response. Pretty quick regulatory response, although it doesn't appear that it'll come in until the 2027. But significantly, it'll apply to any new contracts entered into from the day of the announcement. So the government was mindful of the gas companies maybe entering into agreements very quickly to lock things in. And so I guess I was very surprised to hear that it would apply to anything done on the day of the announcement. The big thing here is I think the gas companies have been trying to pressure the government into approving lots of new projects and maybe fracking and stuff like that. And I think they've had a large level of success. As you can see, the Albanese government has approved around 32 new expanded coal, oil, and gas projects since May 2022. So it's pretty outrageous, really. They pressured the government. The government's rolled over. And I think the real interesting thing here, and this is hopefully you can click that link and listen to Adam Kohler talk about this. But effectively, we're talking the talk domestically. We're trying to get renewables up, proving renewable energy projects. But we are increasing the level of coal, fossil fuels, gas that we're actually pulling out of the ground and we're exporting it. So the way Adam Kohler describes it is like Dr. Jekyll and Mr. Hyde, although he says we don't have to take a potion to change with Dr. Jekyll and Mr. Hyde at the same time. On the one hand, we're saying, wow, we're doing a great job domestically with renewables, but we're the third largest exporter of producer of fossil fuels in the world. And what he suggested, I think it's true, with all these additional approvals, we're going to get to number one. Okay. So the next one was electricity, and this was the Electricity Market Inquiry Report, and it found that households which don't look around and try to find the best plan will end up on the wrong plan and will pay too much. So effectively, they saw that if you went from the regulated safety net to one of the many cheaper plans, you could save quite a lot of money. So we had a funny thing where some of the plans that were offered were actually more expensive than the default offer, and now it's turned around. So you've always got to be looking to see what the best offer is, and there's lots of electricity comparison sites. It's very easy to do, and move your plans to the best offer at the time. You can actually save quite a lot of money. As you can see, the proportion of residential customers paying more or equal to or less of default offers. So you've got, at the top there, more than 25%. So you've got a lot of people who are paying too much, as you can see there. A lot of people switching and getting good benefits. And then the proportion of customers receiving different types of better best offer messages. So this is the number who are actually on the best offer and the ones who are not on the best offer, as you can see. And I'm on the right there. I'm probably not on the best offer, but you can see it's improving, which is good, but still very low, like 20% gone to 25% roughly. And I guess we've all got to be more active in shopping around for the best plan. Maybe New Year's resolution. Okay, authorisations. The Australian Performing Rights Association proposed determination allowing them to continue their arrangements, collect money, and hand it out to all the artists. Effectively, there's concerns about the way these guys operate. I think the big thing, I remember APRA were very heavily involved in trying to stop the parallel importation of CDs many, many years ago, so they have a stellar career, really. But there's a concern there's a lack of transparency in the way they set license fees, the way they distribute royalties to songwriter members. So the ACCC said, okay, we'll allow the thing to continue, but you've got to improve the transparency about how you set license fees. You have to also improve the way your ADR scheme works. So when there are disputes, they can be resolved quickly and fairly. Cash in transit. So here, finally, the ACCC has issued a final determination allowing the ABA and various industry participants to get together to run Lindsay Fox's Armaguard business for him for a period of time and try to work out ways of making this thing feasible. And there's been a few conditions. Obviously, the ACCC doesn't want these guys to do anything anti-competitive, and so there's got to be some transparency in the way they discussions they have and any proposals that they implement. Organic waste. This was a draft determination to allow Sydney Water Corporation and a bunch of councils to jointly evaluate a proposal to develop an organic waste biorefinery, which would be very, very expensive, really, very beneficial in environmental terms. But if they, they want to underwrite the investment, effectively, they've got to say you're getting all our particular waste in order to make this organic waste biorefinery a going concern. And so it's saying you can have a chat, you can see the possibility of doing this, whether it's going to work, and then ultimately there's going to have to be some clear demonstration of the benefits that are going to arise from doing this, both in terms of cost and environmental benefits. Wheat, this was from the previous month in November. ACCC was proposing to allow CHSB to get an exemption under this very, very prescriptive code, the wheat port code. And the main reason, and this is in relation to Geelong, Victoria, and the main reason for that was whether there was sufficient competition in the market to really prevent the exercise of market power by CHSB. And if there was, then they're not required to be subject to any control. So the ACCC concluded there was sufficient competition from GrainCorp and Reardon Grain Services, and also, they will have incentives to provide exporters with fair and transparent access to its services following exemption. So they reckon that anti-competitive risks of them and their exercise market power are very, very low, and therefore they don't need to be subject to the code. Other AI snapshot, the ACCC issued a AI snapshot, so it's good they're thinking about the issues that could arise from that. And nothing really particularly earth-shattering. AI technologies and markets are developing rapidly, raising potential competition implications. Clearly, the algorithmic price fixing allegation probably a biggie. Increased consumer and business uptake of AI may amplify risk of consumer harms. I've probably seen that already. And emerging AI technologies need continued scrutiny from government and regulators. So nothing very earth-shattering there, but I guess it's the first snapshot, and I'm sure they should keep looking at the issues and issuing further snapshots. So hopefully something a little bit more insightful in the future. Finally, in two appointments, Commissioner Anna Brakey was reappointed for a period of 5 years, and Dr. Ian Opperman has been appointed. I think he's replacing Peter Crone, who didn't seem to want to be reappointed, maybe something better to do. And Ian Opperman, a very experienced fellow, knows a lot about consumer data rights and those sort of issues. So a couple of good appointments there. So I guess just a few comments. The Google penalty was definitely too low. Bupa was probably too low. The Google penalty, I guess, was historical, and they were going in a different direction. Two things that I can't understand. I just don't understand that you've sort of you've blocked off an entire market. Search engines on Android phones in Australia for a few years, and you get penalised $55 million for that. That's the first thing I can't understand. I don't understand how Telstra, Optus and TPG don't get fined. They were equally culpable. How these guys don't realise that's a breach, I don't understand that either. And how does no individuals somehow are liable? Like, was it AI developing these agreements, or were there people involved? I think sometimes the ACCC should just run these cases and take out the individuals. That's the only way deterrence. I'm sure that Google, maybe not so much Bupa, but Google, they would have a big celebratory dinner after that penalty. They probably think it's a speeding fine. And Bupa, they've copped a lot of negative press. So they would have been celebrating. 35 million is not much for them, But the negative press they've experienced through all this is something that's going to take a long time to get over. Again, $35 million is probably a bit low for them, I think. City Beach is a strange case. It's getting all these warnings from government departments, and it's just not getting through the senior bosses. Very bad breach. No proven injury or death to any kids, which is great to hear. But really, it's surprising a company that's been in business for so long has so little in compliance, and hopefully they can get on top of all that in the near future. RPM has made another resurgence, and again, the ACCC has shown its desire to resolve these by consent. So if you get done for RPM, you get a letter from the ACCC RPM, just admit it straight away. You get hit with 987B, and it will be over. The last thing you want to do is argue the toss with ACCC because they will sue you. A couple of strange mergers like IAG, I just don't see that's a breach of the Act. I just don't see that home insurance and car insurance is a local market. Obviously, maybe some local, presence has been developed because people are a bit parochial, they like using RAC, but there's nothing to stop an interstate company from offering these types of insurance. So it's definitely, in my view, not a state market. I don't think it's a significant increase in market share. I'm pretty sure RAC is very big in WA and IAG is not very big. And so it isn't really bringing together two big insurers. It's basically transferring the biggest insurer to another insurer who's not very big either in that market. So I just don't think it's, and I think in the light of the ANZ Suncorp matter, I just think they shouldn't have opposed this. I think it's not a breach, and I think AEG will probably take it further. Yamaha's a strange one. It's premised on the idea that Telwater has some sort of strong market position. They can just say to the resellers, if you want aluminium boats, you have to buy Yamaha or outboard motors. Well, that only works if resellers say, well, we don't want your aluminium boats. We can buy them somewhere else, and we can get outboard motors from somebody else. I just can't see that it's a high barrier market, aluminium boats, and I just be very sceptical that Telwater has so much market power, and somebody couldn't step in and offer an alternative package. The other thing is, if they did try that tying, maybe there's an argument that it'd be a breach of 46. ACCC could take them down for that. So again, I think it's a very questionable case theory. Airlines, gas, stevedores, three industries that should be subject to price gouging laws. I don't know why Coles and Woolies, those two companies, are going to be looking at this law. Two companies that probably aren't engaging in it, and the three industries that are definitely engaging in it are just avoiding liability. Airlines, I don't know the solution there. Probably some regulation maybe. Gas, good to see the government has decided to reserve an amount of gas for Australia. Whether it's 15-25%, I don't know, it seems maybe a tad high, but it's a good thing coming in 2027, maybe a bit too little too late, but clever to make it apply to contracts entered into after the date of the announcement. So we'll stop long-term contracts being entered into to avoid regulation. Stevedores, I think they pushed it too far. I think they're going to get done over now with some regulation, and it's a good thing. The ridiculous profits they're making, they're damaging the Australian businesses, trouble importing, exporting, and they're just trying to find ways of squeezing money out of their consumers, and now the government's got to step in and regulate. So I think that's there's been a lot of problems with market failure in that industry all along the line, all the way from the workers, the maritime union, all the way through to the shipping companies, and it's good that the government will hopefully be stepping in with some regulation. And I own this issues are going to be very significant in relation to competition and consumer law. ACCC hopefully have some better insights in future about the big things that are happening in that area. So hopefully that's been helpful. I know it's gone almost 50 minutes, but there was a huge amount of stuff in December. So hopefully that's saved you a few hours of reading all these press releases. And if you have any questions about any of this, feel free to give me a call or drop me an email. Bye-bye.